I'm Terry Doyle, and this is the first edition of our video web series on family law matters. I'd like to start out this series talking about the very basics of family law. Most clients, when they come in, have some pretty basic questions, and after the last 28, 30 years of doing this, I've found that if I can get some information to people in advance of their first meeting, they can dial in their questions to issues that are relevant to their case. So I want to talk a little bit about the process itself, how it works, and what you can expect through this dissolution process. The process starts with the filing of a summons and petition. It's a very simple form to fill out. It's done in literally a matter of minutes with our paralegals, and is filed with the county superior court. The summons and petition is served on the opposing party. We usually do that by mail. We can send that summons and petition to the opposing party. By mail seems like a more civilized route to take, and if they sign a notice and an acknowledgement of receipt, acknowledging that they received the documents, there's no need for a more dramatic formal service of process. The opposing party receives that document, and they have 30 days to file a response. Again, a very simple document to file. That starts the process. The petition and the response are on file at the county courthouse, and the family law matter is then started. Family law matters, divorce, takes a minimum of 6 months in the state of California. The final judgment, the judgment restoring you to the status of a single person, cannot be issued by the court earlier than 6 months from the date we serve process on the responding party. 6 months is the shortest amount of time that the process can take, but typically it takes longer. What I would like to do is to give you some ideas of how to get the process moving so that you can process the family law matter as expeditiously as possible, and make this as simple as can be. The next thing we do once the summons and petition is filed, served, and the response is filed is serve what's known as a preliminary declaration of disclosure on the responding party. The responding party has an obligation to serve the same on the petitioner. The preliminary declaration of disclosure is a document where all income, expenses, assets, and debts are formally disclosed to the other party. This is what I like to refer to as a party's insurance policy against forgetting an asset, because we do use the declarations of disclosure to formulate the property settlement portion of the family law matter. And this is where the insurance policy comes in. If an asset is forgotten, if neither side remembers to include the asset in the settlement agreement, and if it's not on that preliminary declaration of disclosure, it's fair game for division later in life. So it's important for everybody to make full and complete declarations of disclosure of all assets and liabilities, and to make full disclosures of all income and expenses. These are forms that are provided by the Judicial Council. We use these forms, that they serve as a guideline for filling out the PDD, the Preliminary Declaration of Disclosure, and as a guideline for what you need to help us prepare your settlement of your dissolution matter. The types of things that the Schedule of Assets and Debts will require to be attached are things like title documents, deed to the house, the pink slips to the car, credit card statements, bank statements, financial documentation. Our paralegals are very good about helping gather the documents necessary to make a full and complete declaration of disclosure. Once we have that declaration of disclosure, we can easily go through the assets and through an interview with you, help you determine what is community property, what is separate property, and how to allocate to each of you your community and separate property assets. In a later edition of this web dialogue, I'll explain how to make the characterization between community and separate property, and how to occasionally get separate property back from the community that is contributed to the community during marriage. But once that's done, once we have our preliminary declaration of disclosure, we can start the asset allocation process and hopefully come up with an agreement that would be essentially a contract that is entered into between you and your spouse, allocating, dividing, and distributing community and separate assets. That document is what we normally refer to as a marital settlement agreement. It's nothing more than a contract between you and your spouse, allocating assets and liabilities, and allocating responsibilities between you also relative to the divorce. That preliminary marital settlement agreement is then incorporated into a judgment and presented to the court in a form suitable for filing, and that's it as far as the property component goes. There are a couple of other components that I'll talk about in separate web dialogue pieces, including the child custody and visitation piece, the child support piece, and the spousal support piece. So look at those editions of our web dialogue to get some background information on how those parts of the divorce are managed. And with this information, we hope you can give us a call, bring these documents down, and let us help you smoothly manage your dissolution action.